All right, the very meaning of man, woman, boy, and girl has been in the crosshairs of the left for quite some time, even before the U.S. Supreme Court's 2020 decision in the Harris Funeral Homes versus the EEOC case. Now, that case was based in Michigan, but the transgender crusade had its next big day in court in Atlanta, in a case that was heard by the full panel of judges on the 11th Circuit Court of Appeals. The case is Drew Adams versus the School Board of St. Johns County, Florida. And here with me to break this down and what happened today in the oral arguments is FRC's Research Fellow for Legal and Policy Studies, Katherine Johnson. Katherine, welcome to Washington Watch once again.
Thanks for having me, Tony. It's great to be here with you.
So first off, before we get into today's arguments before the court, how did this case start?
This started with a biological female who now identifies as a male in a public school in Florida, which is my home state. And this Adams says that biologically she was denied access to the male bathroom. And the public school said, you need to either use the bathroom in accordance with your biological sex, or you can use a single stall. So they were not even forcing Adams to go to the female bathroom. They gave her the option of going to a bathroom, an individual stall. Yet this was not good enough. And so she sued. She won at the district court level and then won at the 11th Circuit. But the 11th Circuit, it was a panel 2 versus 1. The 11th Circuit has then since withdrawn that opinion and it went to en banc, which means it was before the entire 11th Circuit today.
Any sense how the arguments went today?
They went well. I think it's always hard to tell simply from the arguments, but I think what was most telling was the fact that the 11th Circuit withdrew the original opinion that was in favor of Adams and said, wait a second, we're not satisfied with this opinion. We want to take another look at it. And I think that is what is most encouraging for us to see, especially because 3 other circuits have ruled on this matter in favor of the transgender student. And so this really would be an excellent win for, biological reality. And
right.
This would give the Supreme Court the circuit split to then take up and review the case.
One of the arguments being made by the plaintiffs in this case, Andrew's attorneys, saying that while treating Andrew as his name, Mr. Adams, Mrs. Adams, trying to keep all these pieces, all the parts straight here, treating Andrews equally harms no one else. Discriminating against Andrew inflicts profound injuries on him, treating him as unfit to share common restrooms with his male peers. I mean, this is a biological girl wanting to use a boy's bathroom. The school rightfully responds that this is an issue of privacy and safety for other students.
That's right. I also found that line particularly appalling. First and foremost, we know there are biological realities, and forcing the school to act and disconnect from that is in and of itself a damage. And then secondly, we have seen all across the country in jails, in schools, in Loudoun County, right here in Virginia, where it has been actually dangerous to have people of opposite sex have access to the bathrooms. And there is very much the school's interest in separating people based on biological sex, and there's nothing discriminatory about that. It's simply biology, science, and facts.
Now, Katherine, the advocates of gender confusion are saying they're concerned about this because this could set up a split in circuits, which would mean that the Supreme Court would most likely be at a point of weighing in on this issue of bathrooms and gender and all of this.
That's right. And I actually think there's reason to be concerned of this even going to the Supreme Court. As we know, in 2020, Bostock came out, and that was applied to Title VII situations, which dealt with the employer-employee relationship. And this is a Title IX, which deals with the educational aspect. But the various circuits, including the 11th Circuit and the panel decision, did apply that Bostock reasoning. Now, Justice Barrett is on the court, where she was was not on the court at the time in Bostock, but Justice Gorsuch and Justice Roberts were, and they sided with the liberals. So as of now, there are enough votes from the Bostock opinion. Whether or not the full court or the majority of the court will apply that in the Title IX situation remains to be unseen, but it's certainly something to follow.
Yeah, I would think it might be slightly different in the minds of some justices because we're talking about children and we're talking about minors and being exposed, as you've said. We now have plenty of examples of the danger that this has led to. Katherine, thanks so much for joining us. Always great to talk with you.
Thanks for having me.